jury was sent back for deliberation. It was mixed a little. They had a discussion on the record with the actual charge itself. There was some conversation as to whether solicitation should be included in the entrapment defense. So the record is a little split as to the motion for judgment of acquittal. They started on the motions for judgment of acquittal. They discussed the jury instructions, and then the motion was made, and then the jury was sent back.
Okay, and then after all that, was there a renewal of those motions at the conclusion of everything?
No, Your Honor, there was not.
Okay.
So there was no post-verdict renewal of the judgment of acquittal?
There was not, Your Honor. There is a reason why that motion was not brought.
Was there a motion for new trial?
No, Your Honor. We do have conversations that are outside of the record that are going to go to a later ineffective assistance of counsel claim. I'm not sure if you want me to entertain them.
No, we want to stay within the record, okay?
Oh, well, thank you, Your Honor. 3.380 mandates that if the trial court is of the opinion that the evidence is insufficient to warrant a conviction, then upon motion of the defendant, it shall enter the judgment of acquittal. It's not a permissive or a discretionary rule. It's mandatory if the trial court opines that the evidence is insufficient. And here we have a comment by the trial judge on the record that she did not believe that count 1 was proven beyond a reasonable doubt. Now, a judgment of acquittal should be granted if the state fails to present legally constant, substantial evidence towards each element of the crime as charged. And our Florida Supreme Court has expounded upon that principle by noting that a finding that the evidence is legally insufficient means that the prosecution has failed to prove its case in chief beyond a reasonable doubt. Exactly what the trial judge's comment spoke to.
Let me ask this question, because all we know right now are these were post-verdict comments by the judge, her personal opinion about the verdict, correct?
Correct, Your Honor.
There was no post-verdict motion whereby you argued to the court that your comments appear to demonstrate that the state didn't prove the case beyond a reasonable doubt and would mean to us that there was insufficient evidence to warrant a conviction. So you don't have that post-verdict motion. So what we have here as a reviewing court is a court's comments, which could be characterized as inappropriate or just out of frustration, I don't know. But is there a case on point holding that a judge's post-verdict comments is a legal basis for granting a JOA?
There's not, Your Honor. This case seems to be a matter of first impression in the state of Florida, and it is sort of an anomaly because this court is in the position of being under de novo review, reviewing a rule that does take into account the trial court's opinion. The rule directly notes the word opinion, and even Rule 3.451, which the state references in its brief, that prevents a comment to the jurors after the verdict is returned, there's only one decision of note on that rule, and it's basically the judge telling the jurors at the end, you did a good job. And the appellate court said clearly that was acceptable.
But isn't this more the standard, to follow up with that line of questioning, isn't it simply, it's not whether a trial judge believes, isn't it more that there was sufficient evidence for a jury of reasonable people to find that the crime was proven beyond a reasonable doubt? That's the standard that the Supreme Court has set out.
It is, Your Honor, but it is worth noting that the standard that the Supreme Court has set out does say that if the evidence is not proven beyond a reasonable doubt, then the JOA should be granted. And the trial judge here said not only was the case not proven beyond a reasonable doubt, but she directly speaks to an essential element of the charge, solicitation. Mr. Daly's trial counsel argued the motion for JOA on the fact that the only luring, enticing, or soliciting was done by law enforcement and not Mr. Daly, and the judge, directly reiterating those comments, states on the record, he, meaning Mr. Daly, isn't the one that did all the soliciting in this case. Law enforcement did. I think Mr. Daly was pushed into it by law enforcement. It was suggested consistently. I just think that had it not been for law enforcement, he wouldn't have been there. And she didn't stop there. She continues to predisposition, which is the second prong of the entrapment defense, and she says he had no propensity. They certainly didn't find anything on his computer or anything else about him that would have showed he had this inclination. Again, Rule 3.380 is not permissive or discretionary for her. If she opined the evidence to be insufficient, then she should not have sent that back to the jury.
Well, let's talk about that evidence. A chat log was admitted into evidence, correct?
Yes, Your Honor.
All right. And the chat log, it showed that the detective brought up the topic of children and suggested that they could participate in sexual activities. And here's the kicker for me, and this is something I want you to comment. Didn't Daley continue to enthusiastically explore that possibility? He didn't shut the detective down and say, no, stop, not into that. He went further, and this is a quote. I mean, when the detective initially suggested that the children could be involved, what he responded, oh man, gotcha, that's hot though, you serious? And then he goes on and to say. So he jumped on that.
Respectfully, Your Honor, the appellant would disagree and say that Mr. Daley did attempt to steer the conversation away from the children. Let's move back to the ad that he would have originally clicked. It was an ad entitled M for M, Looking for a Party. 4 words, a completely innocuous title. And it was posted in the adult section of Craigslist that requires the user to click what's almost akin to a waiver representing that you're 18 years of age. After he clicked that, he would have seen numerous ad titles. So the M for M, which means male for male, looking for a party, would have been what initially piqued Mr. Daley's interest. No mention of a child. He then goes to the body of the ad, which stated, single data 2, looking for an experienced NSA guy, only serious reply, DDF willing to host. There's certain acronyms in there that mean something in these sexual advertisement contexts. This is, again, a generalized ad. It says nothing about sexual contact with children. One of the first things that Mr. Daley asks the undercover after he brings up the fictional child is, how do you get free from the kids? Then as the undercover continues to bring up the fictional child, the conversation goes to exchanging photographs. And Mr. Daley says, got any pics? And the undercover replies, oh yeah, I've got some of me, but I can't send any of my kids. And Mr. Daley says, oh yeah, man, not you. I meant not the kids. He didn't want a picture of the children.
But keep on going in the chat log, and there's a lot of exchange going back and forth that pretty much he was really, especially when it came to the exchange about, are you still cool with my kids being here? Yeah, if you are and they are. And then that conversation. And then when the detective said, well, my son just wants to know what you want them to do, and then he went on and on and on.
Your Honor, that conversation, the texts that you're referencing were actually in the text message conversations after it had moved from email into text. And this is after several repetitive requests of the detective bringing up the fictional child. And if you back up a few messages, it's the undercover who says, yeah, just talking with the kids about you coming over. He continually says, you still cool with my kids here? And Mr. Daley responds in very generalized statements, oh, I got you, okay, laugh out loud. And then he continues bringing up the child until the point where he says indirectly, and this is where the trial counsel argued that the solicitation come in, my son just wants to know what you want to do with him. And that's where the explicit messages Your Honor is referencing comes in. But if you also look to his post-interview statements, the state in its brief argues that Mr. Daley admitted that he was going to do this, and that's a contention that we argued back and forth about in the briefs. He has several statements in his interview where the detective says, you came to meet a guy and have sex with their kid, a 12-year-old boy. That's pretty serious. Is that right? Mr. Daley says, I really didn't. You know, I was coming to see you, but you were the one I was talking to. And the detective says, you told me that, and unfortunately that's a part of the record and on the audio that's indiscernible. And Mr. Daley says, and I think this is incredibly interesting because Mr. Daley is for all intents and purposes a layman, and he says, that was until you enticed me to. And during the post-interview, the detective continually refers to Mr. Daley as a fish. He says, I'm a fisherman out here searching for fish, and I put my lure out and you're the one jumping. That's part and parcel of the entrapment offense.
Well, let's talk a little bit about the entrapment. As you know, there's 2 parts. There's either objective or subjective. What position, what are you alleging that, whether is it objective in this case, was it subjective entrapment?
Your Honor, I believe the trial counsel was arguing under the subjective prong, stating that first there was government conduct that induced the defendant to commit an act that he wouldn't have been, and then the second part, he wouldn't have been predisposed to go forward with. And Mr. Daley, as the trial judge noted during her comments, there's really not much to show predisposition here. In the search of his house, and this was brought up at trial, there was no child pornography found on any of the computers. There was no internet searches relating to child fantasies. There was nothing to show that he would have been predisposed. He had nothing in his history, no criminal charges related to this before. And he seems to be a man that interacted with an undercover, and unfortunately, to use the quote that was in Real quoted by the First Circuit, he was a righteous man that had his path turned to an iniquitous one by the repetitive and constant prodding of the undercover here.
How about the evidence that was presented about the conversation that was recorded with his, I guess, his mother, or how do you how do you handle that type of evidence in light of the argument that you're making?
Your Honor, the state points to a conversation with the mother in which Mr. Daly says something to the effect of, I've done something stupid. I don't recall the exact words. But you can't really point to a post-statement to prove that he was predisposed before. The predisposition inquiry looks at the point of the defendant when he's ready to make the action. Is he predisposed at the moment the conversation goes into the sexual undertones? Is he predisposed to commit the crime of use of computer to solicit a parent to commit sex acts upon the child? And the appellant would contend that absolutely not. There's nothing in this record that shows he's predisposed.
And how about, I mean, I have part of a transcript that, so the quote about, quote, I was talking to an older guy and he mentioned something about his kids, and some reason I kind of talked about it, and it went down to Northport and there were the cops.
Your Honor, although an untenable expression to utter in front of this court, it's not a crime for an individual to have that fantasy fetish, and that is the defense that was presented to the jury, that this was more of a fantasy, and that when Mr. Daly arrived at that home, he wouldn't have had sexual contact with the child. He would have only been interested in the adult male.
Isn't that subject to interpretation?
Yes, Your Honor.
Couldn't reasonable minds differ as to the meaning of that? Show me in the chat log where he expresses no desire to do anything with this child.
I think that you can infer that from his first immediate...
But see, an inference is subject to interpretation, so we have a de novo review here, and the judge, if reasonable minds could differ, it goes to the jury. So if you're arguing an inference, I could easily argue the opposite inference.
Correct, Your Honor, but if you're looking for a direct statement that the appellant will contend shows his intent to get away from the sexual child conversation, it's going to be his statement within 2 of the first emails that were sent. This is, how do you get free from the kids? If the detective comes forward and says, I'm here with my kids, I'm hanging with my kids, they're present, we're an open family, Mr. Daly's responding, how do you get free from the kids? I don't want pictures of the kids. The appellant will contend that that shows his intent to have adult relations with the undercover posing as the father here. And clearly the trial judge believed that to be the case as well, based on her comments. Now, Your Honors, there is a second point on appeal that Mr. Daly raised, which is related to the motion for mistrial. Mr. Daly's counsel moved for a mistrial after a statement to the jury in rebuttal by the prosecutor that solicitation is fine, that's not entrapment. Mr. Daly's counsel moved for a mistrial, and the state has contended that it was improperly preserved because his counsel said, I'm going to move for a mistrial. We contended in our reply brief that the insertion of the words going to 2 words doesn't transform the statement. I'm going to move for a mistrial and I'm moving for a mistrial are synonymous, and we believe that it was a proper motion for mistrial. This comment prejudiced Mr. Daly's right to a fair trial because, as the trial judge correctly pointed out, it was done in rebuttal and there was not a chance for Mr. Daly's trial counsel to rebut this improper argument. Not only goes straight to Mr. Daly's sole defense at trial, it was an inaccurate statement of the law here in Florida. The prosecutor seemed to be misunderstanding the real versus state opinion, which speaks to inducement, but he lumped the entire test into one prong by saying solicitation is fine. That's not necessarily true. Solicitation on its own, mere solicitation or the creation of opportunity, is insufficient for entrapment, but continued repetitive acts of solicitation, such as the detective's conduct here, where he keeps referencing the fictional child, he keeps bringing up the child, and eventually comes out and says, what do you want to do with my son, and brings it up directly. Those repetitive acts of solicitation may rise to the level of government inducement required to prove entrapment. And we would contend that the curative instruction that was provided to the jury was insufficient to cure the prejudice that arose from that comment.
And you're right at, you have 5 minutes left, and it's up to you. You could continue on with your argument, or if you'd like to reserve.
Your Honor, our briefs included several issues as to comments raised, but if you have no questions to those, I'll conclude and request that this court issue a written opinion and reverse the appellant's conviction as to count 1.
All right, we still have about 5 minutes, almost 5 minutes. Thank you.
Thank you.
Okay, is the state ready to proceed?
May it please the court, I'm Susan Dunleavy. I'm representing the state on this oral argument. I'd like to address some of the arguments made by opposing counsel. On the issue 1, or 1 and 2, the JOA on issue 1. I would point out that the trial judge granted a JOA on count 2, but denied it on count 1. And the judge is not required to specify her reasons for granting or denying, or for at least for denying a JOA, and typically they don't. Sometimes they do. But the judge understood the difference, as this court appears to understand it as well. The standard, it was stated just a few minutes ago by Judge Kazam, and the trial judge's personal feelings are really of no help to this defendant on this appeal, because, as has been pointed out by the court, there was no post-trial motion for new trial where you can take, the judge can take into account his or her own impressions of whether or not there's a reasonable doubt, whether the weight of the evidence is against the state and in favor of the defendant. Then we're talking about propensity, and opposing counsel argues that there's nothing to show he had any propensity. I think it was shown fairly early on when the detective Bunch says, "We are an open family," and the defendant knew what that meant. That was a code word, and the defendant clarified it by indicating what it actually meant. So he's not, this is not his first rodeo. Whether he enjoys sex with adults as well as children, I have no idea. But he clearly was interested in this. There were periods where Detective Bunch didn't respond to him for, I think there was one period of like 4 hours, and he continued sending, I think, a total of 13 emails over that period. Hey, you know, when are we going to get together? Hey, I really would like to get together, and that sort of thing.
Text, those were texts, not email, correct?
Pardon?
Text. I think you meant to say text, the chat.
Well, I think they started with email, and most of what we have, I think, is email, and then they switched over to text.
Okay.
So, yeah, I would kind of, other than saying they started with email, kind of lump them together. First there's emails, and then they switch to text.
Okay.
And opposing counsel argues, well, even though he drove out there, he wouldn't have had sex with the 12-year-old boy, but in the interview that he had with Detective Bunch, he admitted that he would, but he would have been gentle with him. He was predisposed. He did intend to have sex with this little boy. And the comment or question that he asked, how do you get free of the kids, can just as easily be interpreted as feeling out what the children have to do with this, given the fact that this man has 2 children is mentioned in the ad itself. Single dad, father of 2. So the children have some significance as indicated by the ad, so he's kind of filling them out. And then again, as the court has pointed out, he jumped on it when the dad said, yeah, the kids are going to be here, and that sort of thing. As to issue 3, which involved two different comments, and it's kind of a little bit confusing. I think the only one that opposing counsel has talked about on at this oral argument was where the prosecutor said solicitation is not entrapment, and defense counsel had objected to words to that effect earlier, and the trial court had sustained the objection, but the prosecutor said something similar again. I don't think that it was done in intentional violation of the court's ruling, but more this was really his argument. This was the prosecutor's argument, and so he kind of just gravitated back to that. But at any rate, so defense counsel objected, pointing out that the prosecutor had already been told by the judge that he was not to make comments like this, and he said, I'm going to move for a mistrial. I object. I'm going to move for a mistrial. This has already been decided by the court. And the court says, your objection is sustained. Immediately, defense counsel says, I want a curative instruction. Not, I want a mistrial. Judge says, what do you want me to say? Defense counsel tells him what he wants, tells the judge what he wants said. The judge repeats it word for word, but leaves out the prosecutor's name, just says disregard the last comment instead of disregard the last comment made by the prosecutor.
So there's nothing in the record that would demonstrate that the defense argued that a curative instruction wouldn't be sufficient.
Correct, Your Honor. It was defense counsel who asked for the curative instruction in the first place, immediately after the objection was sustained, and the judge gave exactly the requested curative instruction, and there was nothing further said. At any point before the jury came back with a verdict, defense counsel could have either shortly, right after the curative instruction was given, or even, at some point before the jury was sent back to deliberate, could have said, Your Honor, I've thought about this and I don't think the curative instruction is sufficient. I'm asking for a mistrial. But defense counsel did not do that, so the state stands on its position that on these facts, this issue on this comment was not preserved for appeal. And additionally, on the merits, we believe that the comment was proper. The comment didn't say we can go on and offer various inducements, etc., etc. He just said solicitation is not entrapment. And that's an accurate statement of the law under the Cantrell case, and so there was no error there. And does the court have any other questions for me?
No, I think that's it. Thank you.
Well,
Thank you,
I'll
Ms.
just
Dunlap.
request that the court affirm this case.
All right, thank you, ma'am. Okay, rebuttal?
Just a few clarifying comments, Your Honor. First, the state points to the judgment of acquittal as to count 2 for the proposition that the judge didn't understand the standard here. The appellant would respectfully disagree with that proposition, and you can look to the JOA on count 2 to support the fact that perhaps she actually misunderstood the correct standard. The JOA as to count 2 was a pure legal argument. The state charged the wrong portion of the statute. The portion that they charged him with that was going to go to the jury required direct contact with the child. That simply didn't occur here. So as a matter of law, his conduct didn't rise to what was required for that statute. The state moved to amend the information, but the judge obviously denied that. So again, perhaps she was a bit confused as to what standard should apply, because she clearly stated at sentencing she didn't believe it was proven beyond a reasonable doubt and that she thought he was entrapped. And another
For entrapment to become an issue of law, the facts have to be undisputed. I mean, for entrapment, you've got inducement, propensity, and then whether it goes to the jury. The issue whether it goes to the jury is if the facts are undisputed. So can't we conclude that the denial of the JOA was that the judge felt that the facts were disputed and it was a jury issue?
Your Honor, the appellant would disagree because her comments speak directly not only to entrapment itself and the fact that he wasn't the solicitor.
Well, the comments post-trial, not any of the comments while she's deciding the JOA.
But
correct?
respectfully, Your Honor, we can tell that she had that opinion before she sent the jury back to the deliberation room because she uses present sense impression words at sentencing. She says, I was just stunned when the verdict came back. I was just shocked that they convicted him. But clearly she felt that way when she sent them back to the jury room. Another clarifying point, Your Honor, the ad absolutely did not say singled out of two. The children were not mentioned in the initial ad. They were brought up later on the emails. And as to the state's continued reference, they made a big deal out of it in their brief as well, to the 13 emails where Mr. Daly loses contact with the undercover and sends a string of emails saying, are you still there? Did we lose comment? Nothing in those 13 emails speaks to anything about sexual activity with a child. Your Honors, we would respectfully request this court reverse the appellant's conviction as to count 1. Thank you.
Okay. Thank you both. Really well argued. Interesting case. Thank you all. This. Okay. All right, and our next case is Marion Fritz, Heather Etches versus Neil Forget.